seal the Queen on the application of Black and the Secretary of State for Justice.
Yes, Mr. Reedy.
My Lords, good morning. A very short bit remaining on the principles, and then I'm going to come directly, if I may, to the application of them to our specific statutory context. I wanted to take you back to two authorities on the fifth of my propositions of what necessary implication brings with it, namely that the Crown cannot be assumed at the point legislation is passed to be prospectively inactive. And the first of the authorities is Gorton. You've got that in a couple of places. You've got it reported as part of the report behind tab 21 in Cooper. Mr. Justice Wills, having persuaded the Chief Justice that his own report ought to be reported. And then you've got it again behind tab 19, which I think was the one my learned friend took you to yesterday. So it may be convenient if you mark that up to go there. So tab 19, and the Gorton case was the footnote, if you recall, starting at page 1003. And for present purposes, the significance of it, we submit, is that the court placed real weight against the necessary implication on two facts. Firstly, that the land in that case was Crown and not local authority land. You see the echoes here. It is property over which, to take the wording from the judgment of Mr. Justice Day on page 1005, left-hand column, about three-quarters of the way down, this plot of ground is state property, and it's property, therefore, in my judgment, over which the local authority can have no control whatever. And it's entirely under the control of the Crown and not to be controlled by the local authority. And secondly, they placed real weight on the fact that the Crown, and this is perhaps rather more directly at the point that we're on, but they place weight on the fact that the Crown, I'm now going to the right-hand column on the same page, about just above halfway down that right-hand column on 1005. Here the Crown is not mentioned and no necessary implication of any sort or kind arises, and it is clear that the Crown by its officials is quite competent to provide for the sanitary condition of these houses. And thus it could not be said to be necessary, is the point, to imply into the regime a power in the local authority to inspect or enforce for those purposes. But you see the way that that is phrased. It's phrased on the basis, understandably, because you're judging the legislation at the time it is passed. They're quite competent to provide for the sanitary conditions. So you could say, well, they're cut out from the scheme, but there they are, quite competent. And Mr. Justice Wills is to the same effect. If you go to the facing page 1006 in the MS numbering, he placed reliance, as you see in the final sentence of the opening paragraph on that page, about halfway down, just above halfway down, it is property held and administered by the Crown for the service of the public. And the question, as he identified it, if you drop down to the passage in the longer paragraph in the left-hand column, about 7 or 8 lines down in that, I think you were taken to that yesterday. You'll recall that Lord Dyson quoted this little section in his judgment at paragraph 15. His quotation ran from the question that is posed, about 8 or 9 lines down on the first full paragraph, left-hand column on 1006. How can it be said there's a necessary implication? It's not necessary, as it seems to me, for the purposes of public health and public good, which are intended to be served by the Public Health Act, that this jurisdiction should be vested in the local board. In other words, that the jurisdiction should be conferred upon the local authority as opposed to the Secretary of State. And in large part, or in significant part, the reason for that you see in the remaining analysis in that paragraph spanning the left and right-hand columns. And in particular, if you go about 9 lines up from the bottom of that or from the paragraph break on the right-hand column, it seems to me something like an absurdity to suppose such a thing. There is certainly as much reason in legislation giving credit to the Secretary of State that he would do his duty and would see that the great interests of the health of the public were regarded as in supposing that the local board in each district would do its duty. The protection of the public is as complete and as effectual under the approval or disapproval for the local board. That's not to say they wouldn't apply different approaches, and true it is that there were parallel legislative schemes there, but the point that they make is a general one. You cannot assume inaction. Indeed, on the contrary, the proper assumption when testing whether there will be a void if the Crown is not bound by legislative scheme is not to assume that the Crown will do nothing and therefore there will be a policy deficiency, but to assume that the Crown can be expected, no doubt in modern times subject to all the controls that public law and ECHR and everything else imposes, that they can be expected to perform their duty. That theme is not, as it were, does not rest in the High Court.
Do you mean a legal duty or a moral duty? In this case, there was arguably a legal duty. But in the case that we're considering now, the whole point is whether or not there's a legal duty. And I think when you talk about duty, you must be talking about some sort of moral obligation.
Well, it's a combination. The government generally acts, and whether it was acting under statutory powers or common law powers, would be expected to act in the public interest. One can say that's a moral duty, that's the way the government is expected to act, but nowadays one could cast that as a legal duty. If they were
Well, we had this debate yesterday.
Yes, but if they were exercising, for example, prerogative powers for a private purpose, then that would be unlawful under modern times, and no doubt under in 1904. I was going to say it didn't
say that there's a political imperative as well. If the government is seen to act
contrary to the legislative scheme,
inconsistently with the legislative scheme,
yes,
and of course you also make the point that there is a supplementary judicial review control.
there is. I don't want it all to rest on that.
No, you don't.
No, of course not.
Well, I don't want it to rest on that because that tees up what I respectfully am going to submit is not a fair distinction that my learned friend seeks to draw. He says, well, there it is, all jolly simple. You just make one telephone call to the local authority enforcement officer as compared to having to do a JR. But of course, the assumption that precedes that is that the Crown will be inactive of its own motion. And that is not an assumption that can properly be made.
I wonder whether it rests on that assumption. And surely Mr. Havers is entitled to say, you contrast the two means of ensuring enforcement of the protection. On the one hand, it is easy to summon up the local authority. On the other hand, while the Crown may be expected not to be inactive, there's no guarantee that the Crown is going to, that the government department is going to.
There is no guarantee. Of course, that is right, and of course, at that level, the comparison is apt. But you don't get to JR for obvious reasons unless the government has created, by inaction or by insufficient action, a position where there is a dissonance between the legislative scheme and its import and what the government has done as a matter of policy.
Yeah, but there's a very broad spectrum between total inaction and
it is. There's a
positive action.
I was going to say that this principle, whatever it's based, whether it's based on moral, politics, law, one sees reflected at least in the judgment of Lord Duparc in Bombay. So I said it didn't rest in the High Court. Could I invite you just for one brief moment to go back, and it is the final time we'll go there, to Bombay, Bundle 1, Tab 3, and the passage for relevant purposes straddles 621 and 622 in the MS numbering. I say it straddles 621 and 622 because it's important to see where this fits within the analysis in order fairly to present it. I took you yesterday for the purpose of saying that the test is not one of reasonable efficiency of operation of the legislation to the disagreement between the Privy Council and the Chief Justice. whose decision they were considering. And you see that being dealt with in that paragraph that straddles 621 and 622. But then in the next paragraph, which is the one I want for present purposes, you'll see that the Privy Council goes on, and the premise for this paragraph is in the opening line. Even if the High Court were correct in its interpretation, in other words, that it was a matter of reasonable efficiency, the principle, its method of applying it, would be open to the objection that regard should have been had to conditions which it found to be in existence many years after the passing of the Act, but to the state of things which existed or could be shown to have been within the contemplation of the legislature in the year 1888. So that's the first of the 2 points that is made in this paragraph, and that one effectively says you need to judge this at the date of the relevant legislation is passed, and if you get sucked into reasonable efficiency, you're doing that judgment by reference to events that post-date the enactment of the legislation. That appears to be the point that's being, the first of the points that's being driven at in that paragraph. And that's why I concentrated on saying it's an assumption of inactivity or an assumption of activity by the Crown, rather than getting sucked into the detail of what the Crown has actually done since the Act was passed, which we know, and has included bans on smoking in all the great offices of state and all the departments of state and in the Crown estate. But leave that on one side. That's the first of the points. The second is the one we're after, beginning, it may also be objected that the view taken by the High Court appears to ignore the possibility that the legislature may have expected that the Crown will be prepared to cooperate with the corporation so far as its own duty to safeguard a wider public interest made cooperation possible and politic, and may well have thought that to compel Crown subservience to the corporation beyond that point would be unwise. So that's the point about the Crown being prepared to cooperate, the Crown acting in the public interest, and that is substantially the same point that was being made in Gorton, is evident from the citation of Gorton for that very purpose. See the next sentence. So we submit on the back of those authorities that it is an important part of the necessary implication analysis that the legislature is to be taken to assume that the Crown will properly make judgments in the area where its fiefdom begins, as it were. They will properly make judgments about whether the public interest that is driving the legislation should be introduced, in what form, subject to what conditions, are there specific matters relating to government that would affect it, but they will make judgments in the public interest. And what you certainly can't do is to assume that there will be a policy, if you will, deficiency or a void if that is, if the Crown is not held to be bound. And that is the point that the Court of Appeal accepted below, and were right to do so, I respectfully submit. The relevant paragraph is paragraph 32 in the judgment of Lord Dyson. And it appears that that, at least as a point of principle, was also accepted by the Divisional Court in the Liverpool case. See paragraph 49, MS 666 to 667, Bundle 1, Tab 5, to which my learned friend took you to yesterday. So they appear to have accepted that that was the approach, but then gave very specific reasons for recognising the limits on that in the specific context that they were there dealing with. So that's all I wanted to say about the principles. What would the parliamentary draftsman of our Act take from all that, if one puts oneself into his or now her shoes? The answer to that is very clear presumption against the Crown being bound, long established and long upheld as a principle. No need to clarify that the Crown is not bound so as to move from a position of silence implying Crown not bound. No need to clarify that just because we're dealing with a public health or a public benefit measure. And if they are going to be bound, particularly in a criminal context, there is an evident need for the both the greatest clarity that that is the intention, and then to deal with the sequential questions as to how criminal provisions are intended to apply to the Crown. So, against that backdrop, can I turn to application? And I want to divide these submissions, if I may, into two parts, two broad parts. The first addresses the structure and language of the Act, and the second addresses rather more broadly the purpose of the Act. And the point which I anticipate from yesterday's questioning is troubling the court, which is, aren't we dealing here with an Act which is plainly for the public good? Smoking is a thoroughly bad thing, exposure to passive smoke is a thoroughly bad thing, and wouldn't it carve a great chunk out of that beneficent purpose if the Crown were not bound? I'm going to address that, if I may, when I come to deal with purpose. But so far as the structure and language of the Act is concerned, if I may deal with that first, and five heads under that, some of which will take a little longer than others, but I start with two or three short points. First, there is nothing express. And I interpose, despite that being the easiest thing in the world to indicate. That was a point relied upon by Lord Dyson in the judgment below at paragraph 30. Secondly, we are dealing here with criminal liability. No one before you has produced any example of the Crown or Crown servants, to draw that distinction, being criminally liable by implication. And we submit that for good reasons of principle, the presumption, which is another way of expressing the principles we've been considering, is at its strongest against such an imposition, being the parliamentary intention when criminal liability is in play. Thirdly, the enforcement provisions do create, we submit, a series of problems for the Crown being bound case. Under the primary legislation, of course, the Secretary of State has to designate enforcement bodies, posing, I suppose, the first dilemma, which is himself or local authorities. If it's himself, that creates the Dumbarton dilemma, enforcement against himself being on both sides of the argument. If it's local authorities, that creates different but equally forceful problems of the kind identified in Gorton, with the series of powers to demand information assistance facilities, to enter, and so on, into government buildings conferred, as it were, on local authority officers. Are they really to be presumed to be exercisable against all the departments of state? Local authority tipped off that smoking is occurring in the heart of MI6 or in the Cabinet Office at 70 Whitehall. Not impossible, it seems a little improbable, it might be thought. That's the third point. Fourth point...
Don't we have to assume that that also would have been dealt with sensibly by exemptions recognising national security and so on?
Well, there are possible ways in which it could have been dealt with. And in fairness, it might be thought that possibility does exist, I entirely accept, under the primary legislation, because you can set up those enforcement regulations any way you want.
I mean, if we assume that the Secretary of State will do his stuff in other respects, why not in this?
Well, my lord, you can set it up, as I've accepted, you can set it up in any variety of different ways. But at the moment, and with the regime set up as it is, those oddities at least exist. Put it no higher than that.
I don't want to ask you to guess or speculate, Mr. Eady, if you haven't had a chance to look at it, but I'm just wondering if there are comparable enforcement regimes with powers of entry which undoubtedly do apply in practice across the public service sector. The Health and Safety at Work Act, I think I'm right in saying, certainly does apply to the Crown. Does that mean that the people we used to call factories inspectors have a right of compulsory access to virtually any public building?
Well, I suspect it would if the legislation specifically provides for
Well,
that.
it certainly provides, because I've looked it up, it certainly provides for the Act to apply to the Crown. What I haven't followed up is where that takes us. But there's an inspectorate, isn't there? And there may well be other fields as well where the same thing.
Yes, I mean, I think I don't think I would be submitting to my lord that in the example that you give, and indeed we saw one in the Liverpool case. My learned friend entirely fairly took you, I think, to Schedule 5 it was of the relevant legislation there, which provided that in certain circumstances you had a power of entry, and it follows from the Divisional Court's judgment that that would be an example of the kind my lord gives. So it is possible to do it that way, and if the Crown is said to be bound in your example, I wouldn't be suggesting in those circumstances that the factory inspector, if it was he or she, wouldn't be allowed, as it were, under that scheme to inspect any premises that were triggered by the Act.
I mean, there are obvious practical difficulties with prisons about inspections of all sorts, but I dare say the factories inspectors would have jurisdiction over prisons.
My lord, they might. I don't know.
There are workshops and there are people working.
I haven't looked, but I'm entirely prepared to accept that they would.
Okay.
I don't present this as being a complete roadblock in principle.
No.
I present this particular point as being at least an oddity.
Yeah.
And I think that's partly in the Court of Appeal, but they may have had similar thoughts to my lord, which is why it doesn't feature large in the Court of Appeal's judgment.
Well, I think my lord's question illustrates a point which has been troubling me, and that is that at the time when many of these principles were fashioned or propounded, the Crown's role was arguably quite different from the contemporary position. The Crown Estate, for instance, was a lot more confined than it is now. And therefore, the question of the current applicability of the principles that were decided upon some considerable time ago arises, does it not?
It does. I mean, I would respectfully rather wonder whether that point doesn't sound perfectly happily in the application of the principles. It might be more questionable as to whether or not the principles themselves need to be reshaped.
But I mean, things like, for instance, the inaptness of the local authority controlling the activities of the Crown. And I wonder whether that has any contemporary resonance at all.
Well, it may have limited resonance for the reasons we've been discussing.
Yeah.
But it is at least odd, without specific parliamentary permission, as it were, for local authorities to be given those sorts of powers.
Yes, but that doesn't arise really, does it, to any significant extent in current measures?
In current measures outside the scheme that we're dealing with? Well, it could do for the sorts of reasons that Lord Hughes was indicating. And I've accepted that. I mean, that's the acceptance, as it were, as a point against me. But I fully accept that there may be certain circumstances in which local authority inspectors do go in. But at the moment, and the way the scheme is currently set up, as it were, you'd have to imply that that was the intendment. The fourth of the points is Section 23, and it might be thought that Section 23 really lies at the heart of this. And that, no doubt, explains why in the judgment of the Court of Appeal they devoted paras 41 to 44 of their judgment to this issue. And we respectfully adopt and agree with their reasoning. There are perhaps four short points in relation to Section 23. Firstly, it sits, of course, in another part of the legislation, and it deals with a different subject matter entirely, that other part. But that, we respectfully submit, is not the point and is no part of an answer to the point of interpretation, for the simple reason that Parliament must surely be taken to have a consistent approach when the Act is looked at overall. You read the whole Act rather than just one provision, and you make appropriate inferences about parliamentary intention accordingly. That's an elementary feature of statutory interpretation. Indeed, you would look at other legislation which was not even in the same piece of legislation if it fell within the same statutory scheme. But if it's in the same act, its force, we respectfully submit, therefore, is to indicate that Parliament was entirely alive to the ordinary legislative presumption of not binding the Crown, and when Parliament wishes to bind the Crown, and when Parliament was considering this piece of legislation and they wanted to bind the Crown, they did what Lord Keith and Lord Duparc described as the easiest thing in the world. And they bound the Crown expressly and in terms. And that was done and is only explicable on the basis of an understanding that otherwise the Crown would not be bound. So it stands, we submit, in the plainest possible contrast to the absence of anything similar in Part 1. In the plainest possible contrast, because that contrast exists in the very same Act, which does actually make express provision binding the Crown. Secondly, the nature of that binding of the Crown was then specified and clearly and expressly set out in section 23. And it is doubly surprising, as it were, if the Crown is to be bound in relation to Part 1, despite any express indication to that effect, that no provision is made as to how the Crown is to be bound. And the contrast here is with section 23 sub 2 and 3. Is it therefore to be presumed by contrast that in the absence of something equivalent in Part 1, the Crown is bound in Part 1 criminally and not just by way of declaratory relief, if I can put it that way, focusing on section 23(2)? And if so, how does that work? How does that work? How is that effect achieved? And why is there that distinction? The Crown will not be criminally liable on that conception for the offences that are related, and it might be thought the more serious offences that are related to the safe, appropriate and effective management and use of thoroughly dangerous controlled drugs such as heroin or morphine, but it will be criminally liable, that is the Crown, on my learned friend's case, for not putting up a no smoking sign. So Parliament has, just to alter the animals a bit to the submission I made in the Court of Appeal, Parliament has legislated to cover the cat but not the tiger. But it's difficult to see how that could be the position, whatever system of interpretation or principles of interpretation were to be applied. But how can it be obvious or a matter of necessary implication or logic for health-related criminal sanctions to be available against the Crown in that part of the Act, that's Part 1, but not in relation to Part 3?
What does it actually mean in this context, the Crown being liable criminally? How would the proceedings take place?
Well, that is a live and interesting question, and that's in part why I took you to the Official Secrets Act. But whatever the answer to that question, it is clear that the relevant sections 23, 2 and 3, are drawing a distinction between the Crown on the one hand and Crown servants on the other.
Right.
I mean, we know it's slightly odd because in the Official Secrets Act, you'll recall, Crown servants was defined to include the Secretary of State. Yes. And so whether or not, I mean, one's natural assumption would be that when it's referring to the Crown, you're either referring, it's difficult to see how they'd be referring to the Queen herself, but you'd be referring presumably to the top of the office. You'd be referring to M and the Home Office. You'd be referring to the Secretary of State as the most senior representative of the Crown, one assumes, particularly because in context the distinction is being drawn between the Crown and Crown servants.
Just remind me where the Official Secrets Act definition was.
It was in Bundle 2, Tab 8.
Page 720.
I'm very grateful. and section 12, which contained that definition, is at page 730 in the MS numbering. So that contrast, we respectfully submit, is thoroughly important for present purposes, but it also indicates at a broader level that contrast between 23.2 and 3 and how all that works compared with what my learned friend's case has to be, which is that by implication, the Crown and Crown servants and emanations of the Crown are all criminally liable under Part 1. But what 23.2 and 3 indicate rather more generally is that coverage or binding of the Crown to these sorts of criminal offences raises what I've described earlier as consequential or sequential questions of real importance. And you would expect them to be dealt with. However they ultimately crack the legislative policy of how they deal with them, you would expect them to be dealt with. Should the Crown be bound, or should it be just subject to a JR declaration? Should Crown servants be bound? If so, how should Crown servants be defined? All of that is thoroughly important and is dealt with in section 23, but not on my learned friend's case under Part 1. So we submit that the fact that section 23 is concerned to specify, to echo the learned judge's reasoning at first instance, is concerned to specify the limited way in which Part 3 binds the Crown, we respectfully submit makes our argument stronger, not weaker. The very fact that Parliament went to the trouble expressly of providing for very limited Crown application in Part 3 makes it very surprising indeed that it would not have applied, or A, that it didn't address it at all in Part 1, but B, that it would not have applied something similar, if that was truly the intention, in relation to Part 1. And there is an incoherence in my learned friend's case at the level of legislative intention, so far as that is if that is his case, which it has to be, because on his case, in Part 1, by necessary implication, the Crown is criminally liable in all forms for all the offences that are there set out, including not putting up smoking signs and so on. But when one comes to Part 3, if you just go back to it, it's behind tab 1 of bundle 1, and you go back to page 607 in the MS numbering and look at section 21, I think I'm right in saying that these are the offences. This is the offence, or this is the list of offences which this part deals with. So it sets up the regulatory regime and then prescribes offences, but these are the offences, and you see what they are. Intentionally obstructing a person in the exercise of his powers under section 20, concealing without reasonable excuse, failing to produce, and so on. And then you see, I don't know if friend drew attention to it entirely properly, that the penalty is commensurately greater. But the legislative incoherence is why, just cast your eye across the page to section 23 sub 2, why would Parliament, if you want to put it in these terms, have exempted the Crown from those offences, utterly serious as they are, and far more serious as they are than the offences set out in Part 1, and on my learned friend's case, by implication, rendered the Crown criminally liable for all those lesser offences. That's simply incoherent in terms of legislative policy, and that is the point that the Court of Appeal particularly alighted upon in paragraph 44 of their judgment. They also made the point for good measure, and I think it was the point that my Lord Lloyd-Jones made yesterday to my learned friend. They also made the point at paragraph 43 that if this is truly the explanation for section 23, that it was simply dealing with the manner in which Crown was liable, leave aside all the points I've just made, but subsection 1 of section 23 becomes otiose. It's completely unnecessary. Perhaps one other point deriving from my learned friend's submissions yesterday on section 23. He took you to the explanatory notes and did so in fairness to him, as a convenient and helpful way of summarising what the complicated provisions under Part 3 were trying to do post-Shipman, and appeared at least to hint that this was a complete code with the emanations of the Crown, this is Part 3, was a complete code with the emanations of the Crown plainly involved, because, amongst other things, you've got health service workers and people who would self-evidently be Crown servants, deeply embedded and involved in the accountability structures that are set out in Part 3 of the Act. But of course, when one thinks about it, that point about Part 3 makes his case worse rather than better, because it makes for a far more powerful case of necessary implication. How could Part 3 conceivably work would be the necessary implication argument if Section 23 did not exist. How would Part 3 work unless the Crown was bound? It is self-evident that the people who are being appointed and nominated and designated and all the rest of it under the regulatory regime must include, for its effectiveness, Crown servants. And yet, Parliament did, despite that, the easiest thing in the world and made express provision, and went further and described how criminally the Crown should be liable and Crown servants might be liable. And we do...
Duties in Part 1 are personalised duties, aren't they? And if you look at Section 6, for instance, it's the duty of any person who occupies or is concerned in the management of smoke-free premises to make sure that... So if you are contemplating a prosecution under that subsection, you would have to identify the person who occupied or is concerned with the management of smoke-free premises. So it would be a particular person, wouldn't it?
Not necessarily.
It would be a particular person. One would expect to have that identified, but it could be. It's not very difficult to see. Well, put it the other way, it'd be quite hard to see how you could cut the Secretary of State out from that, concerned as he would be in the management of smoke-free premises on this analysis. But you see the same reference to the same personalised sorts of duties under Part 3 in Section 21. That also creates offences that are committed by a person, intentionally obstructing and so on.
Well, would Section 6.1 apply to a company that occupied premises?
Well, my submission is that it would be. The natural interpretation of person, I'm sure it's referred to in the Interpretation Act somewhere that person includes corporate persons as well as live persons. But one's natural assumption would be that it would cover the corporate as well as the individual. But we respectfully submit that for all of those reasons, this is the killer blow in relation to, what we submit at least, in relation to the issue of, or the issue whether the Crown is or is not bound. And my lady asked yesterday in the context of our 1707-1708 debate what the position was in Scotland.
I wasn't debating 1706.
No, I was. My lady, no.
I was thinking of the Lord President in the much later litigation,
right,
where he adopted a different test that was subsequently disapproved in Dumbarton.
Well, however we got there, I said I would search overnight for the Scottish position, and I made the point, which I think you picked up anyway, which was that Part 1 applies to England and Wales,
yes,
and doesn't apply to Scotland, doesn't apply to Northern Ireland. These are devolved matters, and therefore subjects within the competence of the local legislatures of those jurisdictions. And you have, I hope, on your desks a little white file that looks like that, which is a collection of materials. Just to look at the front, if you would. It contains, just so you see what it's got, the position in Scotland and Northern Ireland in relation to their equivalence to our Part 1. So in Scotland, it's the 2005 Act and then some regulations under it, and in Northern Ireland, it's the 2006 Order. And then my lady also asked about the consultation paper and the response to consultation, which I'll come back to, if I may, when I deal with purpose. But I hope they're helpfully collected there. I know my learned friends team we did parallel work overnight, so apologies for having jumped the gun because they also found these documents. But you have them there helpfully collected, I hope. The Scottish Act, it's perhaps at least worth pausing on. The structure of the Scottish Act is rather different, and one needs to bear that in mind when one reads the legislation, because it starts with the criminal offences in sections 1, 2 and 3, then defines no smoking premises in section 4 sub 2 as places which need positively to be described in regulations. Whereas, as you recall, the English Act starts with a general definition of smoke-free and sets up regulations to create exceptions. And so the definition of no smoking premises is contained not within the body of the Act, as it were, it's contained in the regulations themselves. So they've used a slightly different legislative technique. But I don't think one needs to dwell unduly on that difference of structure. I don't think they contain any specific reference to prisons, but I might be wrong in the regulation. They don't. I'm grateful. But you need to bear the structure of the legislation in mind when considering that. The core point of interest, it might be thought, in relation to the Scottish legislation is section 10. Behind tab 1. And it might be thought that that provision looks remarkably familiar. It's not exactly the same, because the structure of little 3 is a bit different, but it looks to be substantially or materially identical in effect to section 23.
One can draw all sorts of speculation out of this.
One can.
As indeed I was doing yesterday, and as to the consultation with Scottish draftsmen when you've got UK Acts of Parliament which apply to Scotland.
One can, my lady, but I don't. I won't be forgiven unless I make the staggeringly obvious point.
Of course you won't.
We qualify that by my learned friend. The staggeringly obvious points are twofold. One of them is that this clearly indicates that it is at the very least possible to confront directly the very sorts of things that we saw confronted in section 23.2 for the purpose of our equivalent of part 1, and indicates that when you are intending to do so, not merely do you do so expressly, but you do so in a manner which properly addresses the nature and effect of the criminal liability that you seek to impose on the Crown. The second staggeringly obvious point is that Parliament, it might be thought, can be taken to have known at least about this Act. It was made in 2005, as you see, and was made, I think, by the time our Act received royal assent, as you know, on the 19th of July 2006. Now, you may say, well, we can't assume anything of the kind.
Well, I was wondering about that. Among the many hugely interesting questions that this litigation raises is that very one. Parliament can be assumed to know certain things, including what the courts have said about certain things. Can the UK Parliament be assumed to know what the Scottish Parliament has been up to?
Well, it would be pretty surprising, I respectfully submit, if a piece of legislation passed the year before or months before by an equivalent jurisdiction dealing with exactly the same subject matter was unknown to Parliament. That's the submission I make. I put it no higher than that. I've no idea whether someone waved it about when the debates were occurring, and no doubt someone would object to a reference to Hansard if I made it. But the time and the subject matter, it might be thought, naturally lead to that inference.
Well, and section 10 is so...
Remarkably similar to 23.2.
I can't help feeling that at any rate the draftsman must have been aware of it.
One would have thought so, my lord. But
Are there precedents for section 10?
Okay, there are.
in other pieces of legislation earlier than this,
Yes.
that I don't know, I'm afraid. I'm sorry. We can always do some more research on that. So that's all I wanted to say about 23.2. Can I deal, just before turning to purposes, with a short final point in relation to the structure and terms of Part 1, and that is the fact that there is a reference to prisons and other places where a person may be detained in Section 3, Sub 2. And the short point that I make in relation to that is, if I may respectfully do so, to adopt and agree with the judgment of the Court of Appeal on this point. And the relevant paragraphs are paragraphs 46 and 47 on MS 711. And just briefly to summarise, without taking you back to those paragraphs with which I know you'll be familiar, but the short points may be thought of these. To the extent that the Crown is not bound, one might need such a power. To the extent there might be doubt about it, ex abundanti cautela, it might be thought. Once you recognise that there are in existence, and therefore you have to cover private prisons, whatever their precise status, might be thought outside the Crown on any view, but even if there's an argument that they're inside the Crown, you still, as an abundance of caution, would want to cover them. Once you acknowledge that you've got those institutions and you've got to cover them, it's plain that the reference to prisons in the general sense does not lead, as a matter of language or logic or necessary implication, to the inference that the Crown must be bound by the legislation in relation either to state prisons or all its premises more generally. Secondly, that's really the point that the Court of Appeal alighted on in 47. Secondly, that indicator needs to be set against all others, including Section 23, and it builds a case on a single word and has to reason from that case, the reference to prisons, of the Crown being bound across all its estate and all its personnel. It's a very odd way of seeking to bind the Crown, if that's the intention, grouped as it is, in amongst other sets of premises, some of which are obviously privately owned and run, some of which may be mixed, and where the reference to prisons is part of a list of examples of premises where a person has his home. So we respectfully submit that that is, of course, an indicator, and the Court of Appeal took it as such. But it is not a powerful indicator and certainly not sufficient to outweigh. And the point, if there is reliance, doesn't seem to be real reliance on the regulations that sit underneath that. I'm not going to weary you with any debate around the extent to which regulations are properly to be taken into account as aids to interpretation of primary legislation, Hanlon, Mitsui and all of that. But the short point in relation to the regulations is that they raise the same question as the Act raises in exactly the same way. Is the Crown bound? And that was the point that was made by the Court of Appeal at paragraph 36 in their judgment on MS 708.
The point that Parliament must be presumed to have been aware of Section 10 of the Scottish Act is potentially a double-edged sword, is it not? Because on the one hand, it did not replicate that in relation to Part 1. But Section 10, and indeed Section 23, introduces a modified liability for the Crown. And it's arguable, is it not, that the decision of the Parliament of Westminster not to introduce a similar provision to Section 10 of the Scottish Act betokened a decision that a modified liability was inappropriate in relation to Part 1.
My Lord, the reason I chuckle a bit is because it's a mighty odd way of doing it, if that was the intention.
Well, I don't know, is it?
When you've done it in Section 23 in exactly that form, and your intention on my learned friend's case is
the point that I'm making, perhaps an unwitting stimulant for your mouth.
No, I did.
Not for the first time, Mr. Eden, but the point that I'm making is, if it was aware of the modified liability that Section 10 introduced in the Scottish Act, Surely it's arguable that it elected not to modify the liability in relation to position in England.
But only if you take silence as naturally importing Crown bound rather than Crown not bound. First is the first answer.
If it had wanted not to modify,
it would have stripped out
simply have said
23.2.
this shall bind the Crown. Full
It would,
stop.
it would have said it would either have produced section 23.1,
Well,
or it would have produced section 23.1 or 23.1 and 3. And if it wanted to bind secretaries of state criminally, it might have produced a revised version of 23.3. What it would not, I respectfully submit, have done was simply to have left it. That's my submission, anyway. I didn't mean, again, I'm apologising for impertinence almost every moment, but I didn't mean my mirth to be impertinent. But that's my submission to my lord.
No trouble about it.
Can I turn to...
Too late for that.
Yes, it probably is. Can I turn to purposes wholly frustrated, or purposes frustrated? And I'm not going to re-engage in the debate about the adverb. We went over that yesterday.
We've flogged that.
We flogged that one to death, we have. But I do make the point here, and it is perhaps an important point to bear in mind when you're reading the Court of Appeal's judgment, that the Court of Appeal's approach used the adverb, wholly frustrated, it is true, taking that from the House of Lords and Privy Council authorities, but they used the adverb, but their reasoning did not turn upon a use of that adverb in the extreme sense that we discussed it yesterday. So they didn't say, it was no part of their reasoning to say, if I can find any purpose to this legislation. That's why I made the point I did yesterday, that we don't assert that, because otherwise it would turn it into an absolute rule. But they didn't reason on that basis. What they actually did was to examine purpose more broadly. They didn't say we can identify some other purpose, the other purpose is to apply it to private stuff, that's the end of that. They took the Crown-bound or not purpose on its merits, despite having used the adverb. So it's evident that they were using the adverb not, and taking the adverb to mean, not that extreme sense that we discussed yesterday, but as an indicator of the seriousness of the undermining of the purpose. And their reasoning on purpose is contained in 39 and 40 of their judgment. MS 708, sorry, both of them on MS 709. And the position in relation to the frustration of legislative purpose starts, we respectfully submit, from the position in which the position in relation to government departments and prisons, and if you will, the Crown Estate, but take those two as examples, is governed by the combination of government policy and the lawful constraints or the legal constraints on that imposed by public law and ECHR, rather than the criminal law. That's the dichotomy. And the Crown operates its own policies in relation to those buildings and in relation, for example, to prisons. And there's nothing, we submit, radical or surprising about such an arrangement. It is the conventional picture of the Crown developing policies in its area, taking account, no doubt, of legislative schemes that exist in the same area, but not being bound or being subject to the criminal legal enforcement provisions of the Act. And we respectfully submit that doesn't frustrate the purpose of the Act in any way. It can't be said as a matter of principle that the purpose of the legislation that we're dealing with was necessarily to extend a smoking ban to all public places, including the Crown. That assumes the very thing that has to be demonstrated. Of course, the government policy plus public law side of the picture, on our argument, raises the possibility that the Crown may decide to adopt some position other than the entirety of the otherwise applicable Part 1 scheme in relation to some of its properties, e.g. prisons. But, and it's quite a big but firstly, that depends, at the point of the legislation being enacted, on an assumption that the Crown will not adopt something equivalent and will not have a rational policy reason for doing so if that's its decision. And it's fundamentally wrong, we respectfully submit, to make that assumption. The correct assumption in principle, and the one adopted in the cases, is that the Crown can be presumed to make appropriate, they may not necessarily be identical or the same, but appropriate public interest judgments. And so however else you approach the issue of purpose, it is fundamentally wrong, we submit, to approach it on the basis that unless the Crown is bound, that would cut swathes out of the beneficent purpose of the legislation, because that assumes no introduction of equivalent policy by government. And as a matter of fact, not that this is relevant for the reasons given in the first of the points I took you to this morning in the speech of Lord Duparc and the Privy Council, not that it's relevant because you tested at the point the Act is passed, but as a matter of fact, we know that there are no smoking bans, no smoking policies in all government buildings, effectively. But we also know, and we'll get to this when we come to the white paper more specifically, but we also know that if you ask the question at the moment the Act was passed, is it government policy to have smoking bans or to have policies that deal with the risks of passive smoking? Is it government policy to start from the premise that passive smoking is a thoroughly bad thing and policies need to be developed to deal with it and the exposure to passive smoking in government buildings? The answer to that question, at the time the Act was passed, is perfectly obvious. It was plainly government policy to seek to protect those who work in public places, including government buildings, from the effects of the smoking ban. There's no debate, therefore, about the fact that smoking is a bad thing. There's no debate about the fact that passive smoking is a thoroughly bad thing. There's no debate that government policy is premised on those two features. And that makes it all the clearer that it will be a thoroughly illegitimate, both in principle and factually, a thoroughly illegitimate assumption at the moment the Act is passed to assume that unless the Crown was bound, the effect would necessarily be to cut a swathe out of the beneficent purpose of the Act. The intention, and as it turned out, the fact, is that you would end up in government buildings with very, very similar, if not identical, bans. My learned friend, Mr. Havers, says, well, public law, if one gets to that place, and as I say, we only get to that place on certain assumptions, but public law is a poor substitute for criminal enforcement and criminal enforcement of the kind you see set out in the Act. But that, we respectfully submit, first objection to that way of putting things is that it implicitly asserts an inaccurate test, which is that the court is here engaged in an exercise of working out whether the Act could work better if the Crown was bound. Would it work with greater or more reasonable efficiency if the Crown was bound? And we know that that is not the test. So this poor substitute point implicitly assumes or asserts an inaccurate legal test. Moreover, this is not, ultimately, we submit, an efficiency contest between JR and local authority enforcement. But JR certainly exists, and we assert it, to constrain the lawful choices that are open to government. And we explored yesterday how various types of challenge might be made were the government to do the hugely unexpected and deeply unfortunate thing and just ignore, for the purpose of its buildings, the risks of passive smoking. But before you get anywhere near that, you have to assume either inaction by government on that front or the introduction of policies that are said to be deficient and therefore to tee up the need for a rationality challenge, a challenge based on the creation of a legitimate expectation, a challenge based on the ECHR, a challenge, if you will, my learned friend relied on EU legislation based on EU law and no doubt potentially the EU Charter. But before you get anywhere near that, the assumption has to be that they haven't covered it and covered it properly. Moreover, we don't accept that there aren't good reasons despite the fact that that's how it's ended up, despite the fact that that was always evidently the intention to introduce policies of this kind, we don't accept that there are no good reasons for this area being subject to government policy decision-making to protect the public interest and operated in the public interest as compared to legislative intervention. I mean, prisons are perhaps a decent example of that, but one can think of others in the MOD context, for example, where you might want greater flexibility or to introduce changes in a more measured and less immediate manner. And there's nothing wrong with that. So we simply do not accept the legitimacy in fact or in principle of the approach that seeks to test whether the Crown would be bound in effect against a presumption that if it were not, the beneficent purpose of the Act would be subject to a serious legislative policy deficit. So far as the legislative purpose materials are concerned, we do, again, respectfully place reliance upon and agree with the entirety of the reasoning that the Court of Appeal set out in this respect in paragraph 39 of their judgment, MS page 709, and we submit that that provides a complete and correct answer to this point, even leaving aside the point they make in paragraph 40 about government being expected to operate in the public interest. I just want to go back very briefly to a couple of documents, if I may. I think I'm well within the time, so if I may. Can we go back to the white paper, first of all, that my learned friend took you to yesterday? It's in Core Volume 2, in the appendix, at MS 532. This is 2004, I think. I know a friend gave you the date yesterday, but I think that's right. You see that from the top of the page in the shaded bar.
It is a pity we don't have any more of it. I mean, it seems to start in the middle of
a section.
Of a section.
It does. My lord, I'm sorry about that, but we can note.
Anyway, you're all happy that it is representative.
I think the guts of it is here, but we can do a double check on that, and if there's more, we can furnish it if we may, and I invite you to stick it in our little white file. And the points that can be drawn from this, we respectfully submit, are first of all that this document demonstrates, and this is the point that the Court of Appeal picked up on in para 39, is that the 2006 Act was seen as a health measure intended to shift the balance significantly in favour of smoke-free environments. You see that from the first bold passage in the left-hand column under para 76, about halfway down the left-hand column. And that is a phrase that was repeated in the explanatory notes to the Act at paragraph 6 in 2006, Bundle 2, Tab 13, MS 919. So it's exactly the same phrase that's then used.
What was the reference again?
Bundle 2, Tab 13, MS 919. So it's exactly the same phrase that gets repeated when the bill is presented to Parliament.
MS what?
919. I'm so sorry, my lord. And on any view, said the Court of Appeal, and we respectfully agree, it did that. That is not an assertion, as it were, or an indication of intention to cover all workplaces, all environments, or to do so through legislative intervention as opposed to government policy. If one then goes to the right-hand column, you will see that the two bullets, the first two bullets, draw the positive contrast to which my lady drew attention yesterday. By the end of 2006, all government departments in the NHS will be smoke-free. By the end of 2007, all enclosed public places and workplaces other than licensed premises will, subject to legislation, be smoke-free. So the evident intention is that before the legislation cuts in, the government will, as it were, by policy, be ahead of the game. That's why I said if you judged it at the moment of the act, the policy intention is clear and was evident, namely, to do things, so far as government is concerned, by policy, and not to leave the policy deficient void post-legislation.
Was there the equivalent of a white paper preceding the Scottish legislation?
I don't know, I'm afraid. We will check that too, if we may. It then refers, this page, to consultation, and you will see that it does so in the final paragraph on that right-hand column on MS 532, and it refers very much, as the Act does, to prisons. And the consultation, which you have behind, just to show you the relevant bits, that you have in our little white file behind tab 4, 4 is the consultation and 5 is the government response. And the relevant passages are, well, the key passages perhaps for this purpose are on page 9, para 23 behind tab 4. Do you see the reference to prisons or other places of detention in the final bullet on that page?
Sorry, page 23.
Page 9, para 23. Regulations may exempt the following premises from the smoke-free legislation. Final bullet on the page, prisons and other places of detention.
Have we in?
We're in tab 4 of the little white file.
Yeah.
This goes out in 2005, does it?
Yep, I'm tracing it through. 2005 this. So this is page 9, para 23.
Yes.
The introductory line and a half to para 23 and the final bullet on the page. And then in the response, if you go into tab 5, and hopefully this is not page numbered, but if you flick through about 10 pages in, you'll see lots of boxes, and if you can find question 6, para 23 that we just looked at, was followed by question 6, which asked question 6 in relation to the paras that have preceded it, and the government response to question 6, you see, has a bit of material about prisons as well. So we're in tab 5, about 10 pages.
There are a number of letters from prisoners.
Yes, and above that, in the second para of that same box, among others, the consensus appears to be that smoking should be only permitted in private rooms or cells.
Thank you.
And not in the common parts. But my Lord is right, it's really that.
So which question is it?
It's question 6, my Lord. I'm so sorry, they're not page
No,
numbered.
that's all right, thank you.
About 10 pages in.
Yep.
Question 6 starts halfway down a page. And I was drawing attention to the reference to cells in the second paragraph. The letters from prisoners that my Lord Hughes referred to.
But what do you get out of that, Mr. Ely?
My Lord, I respectfully submit that we don't get much out of it because what this does, effectively, is to ask a series of questions that are relevant, however the new regime falls to be enforced, whether it's enforced under the Act pursuant to the criminal provisions or whether it's enforced under policy. It's still a matter of interest, and we know, perhaps more fundamentally, that the Act, when it was passed in section 3.2, did indeed include the reference to prisons. And so, as it were, it's entirely consistent with that. Once one's got to a place where prisons covers private and public and you get into that debate, all of this part of the piece is to similar effect. But for good measure, they're consulting on and interested in the views of the public and those who respond to these sorts of things on what the position should be in relation to prisons, whether it's private or public, and whether it's under the Act or under some other scheme dealing with policy. So we respectfully I've drawn attention because the court expressed interest in it, but we submit that it doesn't add a great deal to the sum of human knowledge, particularly once one recognises that the Act, when passed, contains section 3.2. So my answers are either, and the Court of Appeal's answers to that point, are either good or bad, or of greater or lesser weight. But I don't respectfully submit that this adds a great deal.
It's difficult to think that the people who drafted these documents were thinking of, when they consulted about regulations under the bill, were just thinking of private prisons, isn't it? They don't seem to have distinguished in their mind between public and private prisons.
My Lord, I think that's entirely fair. And indeed, my learned friend took you to ex post documents, the PSI and so on, which appear to indicate the same. But if only I could say that what government thought about a piece of legislation and its meaning was a relevant aid to interpretation, my life might be a bit easier.
But there's nothing in the actual parliamentary material. We haven't been shown anything. There's nothing there which would.
Well, there was a big debate, as you'll have seen from Mr. Justice Singh's judgment, about the admissibility of Hansard material, and both sides relied on bits and pieces. I mean, the closest one comes to in terms of something rather more definite in the sequence of this. And if one's looking to ascertain, as it were, broad purpose, then it may be legitimate to refer at least to this. If you go, you remember we were looking at the white paper at 532 in the appendix. If you go to the next document but one, starting on page 536, you will see that there was a House of Commons Health Committee report on the bill. So this is part of the parliamentary scrutiny. So I'm at 536 of the appendix on the MS numbering. And that committee evidently thought it was pretty surprising that what they described as the issue of Crown immunity, which is Crown bound or not bound, hadn't been referred to in any of these materials and wasn't referred to in the bill. And if you go to 537, let's have a look at number 7, and you'll be very well aware of the structure of these documents. The bold section is the reference from the report of the committee, and the unbold section is the government's response. But 7 is of at least some little interest, perhaps.
Paragraph 62 is their report, is it somewhere?
That I think is their report to which this is a response.
Yes, quite.
But in the usual way, but I mean, at the very least, that.
So both sides there seem to have accepted the principle that it wouldn't actually apply to Crown property.
Yes, and there at least is the promoter of the bill saying to the government committee, when taken to task in a pretty critical way about the fact that this hasn't been referred to, well, there's a reason. Now,
this is all ex post facto, is it?
No, this is before.
This is before, is it?
It refers to the bill you see in the third line of the bold bit of 7.
Yeah.
March 2006.
So, I mean, we're not asked to take this into account, or are we asked to take
Well, my Lord, to the extent that one's analysing purpose, there is a question about admissibility of all this parliamentary material in the usual way. There appears to have been something of a desultory debate before Mr. Justice Singh about these materials and their admissibility. And he said, Mr. Justice Singh said, no weight is to be attached to this little thing, this little bit, because that's to confuse the views of the Minister with the views of Parliament. And of course, true it is that Parliament then enacts.
Well, wait a minute, this is the government response.
This is the government response to a pre-legislative committee, yes, criticising it for not referring. And my respectful submission is that if you can look to ascertain the purpose, and if you're in the territory that we're in for the purpose of this point, which is to see legislative
mischief,
purpose,
what's the mischief? Yeah.
Mischief. This must be admissible and relevant.
I mean, we certainly looked at this sort of material. It goes back a little bit.
Wilson,
my
First
lady and
County
I,
Trust and all that.
in Assange, actually.
In Assange as well.
We looked at a lot of committee material.
Yeah.
But what was the case you were referring to?
Wilson and First County Trust, Lord Nichols, if you recall. But for the purpose of purpose, but that was more to do with ECHR proportionality analysis. But we're not here dealing with interpretation, so we're not really in pepper and heart territory. We're in purpose.
Whereas in Assange we were in interpretation territory.
Yes.
So even then,
what can perhaps at least be said is that this is the point being flagged up
Parliament with its eyes open
before the bill is passed.
Exactly so. But my Lord, it's all of a piece we respect. That's why I've taken you through the sequence, because you see the white paper with its distinction between policy and legislation. You then see the consultation with its muddle up of prisons. But then you see the committee in Parliament saying, well, hang on a second, this is all a complete muddle. And why haven't you done it? This is a criticism of government.
Well, it is a muddle, isn't it? Because the PSI, which is issued by the government shortly afterwards, clearly assumes that legislation does apply.
Or the,
PSI, which is issued after
Service.
yes.
instruction, clearly assumes that legislation does apply. You say mistakenly.
Well, it does, but that's at a considerably less formal. And,
I understand that. I understand the point, but muddle is hardly good enough, really. For it.
Yeah, well,
That's at that stage would have been a Home Office responsibility, wouldn't it? Just before the move.
I think it was probably just before the change to MA.
I think the move was in the middle of 2007.
My lord, yes, but as I say, I don't take.
So this is Department of Health proposal.
At this stage, I think, but this is the minister promoting. This is the government's position.
Yes,
there
right.
it is. This is a formal response to the committee for this purpose.
By the Secretary of State for Health. Yeah.
Yeah. And as I say, I don't shrink from the from accepting my lord's point. It was a right old muddle, and the PSI, it might be thought, was in a right old muddle about the source, but to some extent, in point of substance, it might be thought there wasn't a great deal of difference, because what they were doing, as it turns out on our analysis as a matter of policy, was in effect to replicate the Act. They just thought they were doing it under the Act. So there's no policy deficit in what they were actually doing is a substantive point. The legalistic point, if I'm allowed to make it again, if only gently, is I wouldn't be allowed in this court, indeed in any other court, to turn up and say, there's a PSI which suggests that the Crown is not bound. I can rely upon that for the purpose of persuading you that the Crown is not bound under the legislation. And so the converse must equally true, this time accidentally in my favour. But we respectfully submit that's of a different order to this, which is pre rather than post, formal by the Secretary of State for Health in response to a specific criticism on the very point.
It is quite striking, the omission from all of the consultation documents, from the white paper to the consultation paper, which I've been reading, plus the annex, which was the impact assessment, plus the cost-benefit analysis, plus the response, that nowhere is it said, of course, none of this will apply to the Crown, Crown buildings.
My lady, I respectfully agree, but if I'm allowed to put a little caveat in there, and it's only a little caveat, as you drew attention to, and we respectfully submit rightly, the white paper at least did appear to draw, albeit slightly opaquely, that distinction in the two bullets. Yeah. And we've now seen a document which makes that rather clearer, and it may be that my lady's thought is exactly the thought that led the committee to produce this criticism which elicits this response.
It is totally striking.
Yeah.
They're talking about total ban, all workplaces, discussing various specific exemptions, at no point saying, oh, but it won't apply to government buildings anyway, because we'll do the right thing anyway, which is...
Well, they do say that. They do say that in the white paper. They do say that they achieve that is going to be the distinction in this answer. And when you get to the preamble to the Act, I accept this is a light aid, as it were, but when you get to the preamble, what you're really asking is, was the intention of the legislation to apply to, as my lady's just put it, all workplaces, all premises? And the preamble to the Act, as you will recall, I think you only get it in the full version of the Act in Bundle 2, Tab 13, page 818. The aim was to make provision for the prohibition of smoking by force of criminal law in certain premises.
Oh, well, certain premises, yes.
Well...
we know that.
Well, but it says we know that, but we know that only if you put a certain inflection on certain. The inflection that I put on certain is certain as in not all.
Yes, well, that's the same point the Court of Appeal makes in 39, is it?
Yeah, in part.
That I'm not quite sure I'm following, Mr. Reedy. It's certainly true that the Act does not create what in some quarters would be called a blanket rule, applying to every known sort of premises. That I understand perfectly. It's only some premises that are covered. But the method of categorising the premises owes nothing whatever at all to whether it's public or privately owned, does it?
Well, it could cover both. Is my
precisely. It treats them indiscriminately. It applies the same qualification to both, doesn't it?
It does, but then the question is whether one reasons on from that to say, and so that's what it was dealing with. It was drawing the distinction between that different type of premise as opposed to the public-private, if that makes, I mean, but
I
you
see.
can take it as both, is my
Okay.
short answer. I say it's a light aid and no more. Whilst we're still on broad purpose, two other short points, or perhaps three other short points, and then I will finish. The first is that my learned friend said that in considering purpose, there was every indication when Parliament passed the legislation that the voluntary system, as he put it, had failed and was ineffective, and that's why Parliament was legislating. And no doubt, in a sense, that is true. But if the purport of that point was, and it would be only relevant if this was the intended purport, to include within that government policy, that point doesn't run at all. There is nothing to indicate that there had been a failure, or there would be a failure, to protect those in government buildings through government policy, and that the voluntary system in that sense had failed. Indeed, on the contrary, we saw from the White Paper that the assertion of intended government policy was that all government buildings should be covered by the end of whatever date it was, 2006. And so that point doesn't take him anywhere on this argument, namely, is government bound, is government not bound? Secondly, no support is to be derived, we respectfully submit, from the international dimension, the international materials to which reference was made. He made reference to two. The first of them was the WHO Convention, as you will recall, to which the United Kingdom is a signatory and on which we place considerable reliance, amongst other things, in the plain packaging litigation that was recently before the Court of Appeal. But that doesn't assist in the issue which confronts my lady and my lords in this appeal, because it does no more than to establish, if I can summarise it in the most summary form, than establish the fact that smoking is a thoroughly bad thing and so is passive smoking, a proposition with which the government wholeheartedly agrees, and on which much, if not all, of its policy in this area is premised. The EU material upon which reliance was placed likewise does no more than that, and neither instrument, WHO nor EU, is remotely sensitive as to the manner in which a national authority, a national state, implements whatever obligations might be imposed under the EU system or more generally under international. It's a question of results rather than manner of implementation. So that if, for example, someone were to have a crack at the United Kingdom based on the WHO, in whatever forum you're allowed to have a crack at the United Kingdom under that convention, the answer that the United Kingdom would give would be, no doubt, here's the legislation that covers the private material, the private area, and here are government policies that are properly enforceable as government policies and protected by all the relevant public law that exists. But so those international materials don't dictate the manner in which any result that is imposed on them on the international plane is to be achieved. But finally, my learned friend pointed to the anomalies or the strangenesses if his construction or interpretation or approach were not to be accepted, and referred you, I think Lord Hughes asked for the page number again, as it were, of his list of government buildings, but one needs to be jolly careful with them because if it really is of interest, no doubt an exercise could be done to indicate which of those buildings government policy does or does not already cover. In other words, where there is an equivalent position created by government policy, and to the extent that one enters into much more difficult territory where you're dealing with, I don't know, a connection to the Crown, which is simply because a private restaurant leases land from the Crown, or something of that ilk, well, it's no part of my case to assert that they would escape on the basis that the person who leased that land could be said to be the Crown for this purpose, but you could have a debate about that. That's sort of...
Well, they obviously wouldn't, would they?
my submission is no.
If
but
you're in possession of premises, it's clearly addressing
you're covered.
people who manage it and that sort of person, yeah. Occupy or manage.
Yeah. So you'd have to bring yourself within the Crown. But there may be debates around what the Crown means, that's all I say. But I particularly urge caution in relation to the lists and the assumption that goes with it, which is what gives the point its sting, if at all, which is that you've now got a void inconsistent with the policy of the legislation by virtue of that list. My lords, my lady, unless I can seek to assist further, those are my submissions.
I think not. You've been bombarded with plenty of questions in the course of your submissions, so we seem to have run out of steam. Thank you, Mr. Eady. Mr. Biewski?
Can I begin by just adding two further documents to those that Learned Friend handed out earlier this morning, and provide the court with some further information pursuant to questions that you asked yesterday. Firstly, I'm going to hand round, or ask to be handed round, the whole of the 1865 Locomotives Act.
Oh, good.
Must be.
It'll cut the Gordian knot immediately.
Can you give me another copy? It's brilliant. Have you got it? Yes.
Oh, it's a relief to see that the massive document is not the whole of the locomotive.
No, it's not. No, that would have been a surprise.
Yeah.
And if you go to section 8 on the third page, you can find where the previous copy ended, and if you then go over the page, you can find the rest of section 8, which provides that what the local authorities may do is to, and I pick it up after item 5, may make orders as to the hours during which, and as to the speed, not in any case to exceed 2 miles an hour, at which locomotives are to pass through the city or place, subject to their respective jurisdictions. And then provision for the penalty of a fine of up to £10. So that's the rest of section 8, and it confirms not only the power of the local authorities to reduce the speed, but also to make orders as to the hours during which locomotives may pass through the city or place in their locality.
Not to exceed 2 miles an hour.
Not to exceed 2 miles an hour. That's presumably because those are more built up than the open roads where a maximum speed of 4 miles an hour was to be permitted. The other document that's been handed up, you'll be relieved to hear that we're not going to invite you to read it, but have another copy. But this is a document which sets out, albeit for the whole of the United Kingdom, as I understand it, but sets out, as one sees from the first page, central details of central government property and land, including Welsh ministers' estate. So the inference would be that central government property and land would, on the face of it, be Crown premises, and the point of handing it up is to indicate just how many different offices, for example, or buildings, for example, the Ministry of Justice, just to dip in, or the Department of Work and Pensions have up and down the land.
I'm glad to see that you realise now that this includes all the magistrates' courts and other courts across the country.
Yes. Yes.
It wasn't on your original list.
No, it wasn't, my Lord. And then all one needs then do, all I invite you to do, is then go to the very back, the last page of the document, at the at the back, where you will see that the different offices or buildings in question amount to over 13,000. That's the very back page of the document.
Because they're sequentially numbered.
Because they're sequentially numbered, exactly. So that provides some indication of the scale of the of Crown, well, central, where is it mean? Of central government property and land. Whilst on statistics or figures, we also researched overnight with a view to answering my Lady Hale's question as to the number of how many employees work in Crown premises. The ONS don't publish statistics specifically addressed to that, but they do publish statistics which, the most recent edition of which shows, and these are statistics for public sector employment in the United Kingdom. We can hand up the document if you would like us to, but it may suffice if I simply extract the key figures now for your lordships and my lady. The total UK public sector employment figure is 5.44 million, but that of course is total UK public sector, so that is not going to assist. So of more interest is the total number of central government employees. That is 3.021 million. Civil service employment amounts to 423,000, but there's nothing to indicate in the document that that is to be considered as additional to the central government employment figure. So I'm not going to add it to the central government employment figure for the time being. NHS employment, and the NHS is now smoke-free, as the court knows, was 1.621 million. So if one extracts that figure from the central government employment figure, one arrives at a figure of 1.4 million for the UK as a whole.
Why would one extract that?
Subtract it? Well, only to reflect what's happened since. Of course, at the time of the Act, the full figure would have been the appropriate figure. Well, it would have been lower than that because the numbers have increased since then. But at any rate, looking at the position as at today, if one takes out NHS employees, one arrives at a figure of 1.4 million. For the UK as a whole, it is possible, by reference to a table in the document, which tells us how many total employees, relevant employees, are employed in England and Wales as opposed to the UK as a whole, to derive at an England and Wales figure of 86% of the total. I'm getting, I know, rather too precise for your ladyship's purposes. But if one were to take 86% of 1.4 million, one would arrive at a figure of just over 1.2 million. The point is that, on any view, we're talking about very large figures indeed, to which must be added, we submit, all those people who visit these premises, who, if my friend is right, won't be protected by the Act, and, of course, prisoners. And the court may be interested to know that currently 86,000 plus, there are 86,327 prisoners in England and Wales. My lady, the only other further information to bring to your attention was in response to the Lady Hale's question as to whether there was anything by way of an explanation to be found in the response of the government to the fourth report of the Shipman Inquiry as to why Part 3 of the Act should apply to the whole of the United Kingdom rather than just to England and Wales. The response document is a very long document indeed, so again, unless you'd like me to hand it in, I wasn't proposing to do so. But simply to read the relevant paragraph in the executive summary after setting out the government's overall approach. Paragraph 6 of the executive summary reads, "The programme of action," and the response sets out a detailed programme of action, "will apply in detail only to England. Scotland, Wales and Northern Ireland will respond separately, although in general any changes to misuse of drugs or medicines legislation will apply throughout the UK." If it would assist, we can hand up simply that page, but that's the explanation that appears to...
What was the explanation? The explanation was...
Well, as to why the part 3 of the...
Specific action is limited to England, Wales, programme of action.
No, yes, but if there was to be any change to the legislation, that the response document says would apply throughout the United Kingdom.
Because medicines legislation is UK-wide, is that it?
UK-wide, yeah.
Yeah.
So, can I then turn to respond to some of the points raised by my learned friend in his submissions? At various stages, my learned friend, and in the context of various different points, my learned friend referred to how absurd it would be if local authorities were entitled to barge into the parts of MI6 or MI5, or he includes in his printed case the MOD, and that can't possibly have been the intention of Parliament. True it is that under Schedule 2, premises may be entered by an authorised officer of a local authority, but your Lordships and my Lady will remember that if entry has been voluntarily refused, then he may only do so if he has written authority from a JP. Secondly, the court will recall that in the Liverpool coroner case, the commissioners also relied upon the intrusive powers as they were described in arguing that the Crown was not bound. The reference is paragraph 36 of the report. In that case, MS number 663, but that argument failed, and I showed you the powers yesterday under the relevant schedule in the materials that supplementary materials that I handed up. It is, we submit, wholly unsurprising that Parliament should have intended that those who work in or visit MI5 should be protected from passive smoking to the same extent as everyone else. And there's no evidence to support this, what we suggest is rather alarmist submission, that somehow national security will be put at risk if such inspections were to be made. In practice, of course, it's difficult to believe that sensible arrangements couldn't be arrived at between MI6 and the local authority to permit the local authority to inspect the part of the premises in question without any threat to national security arising as a result, which is why we suggest that the suggestion is in truth somewhat alarmist. But if there really is a problem about this, then either that problem could have been addressed in the statute, or the regulations, I should say, exempting MI5, MI6 and the MOD from the application of the Act, or later regulations could have been made doing so if it turned out that there really was some national security risk in play. But coming back to prisons, private prisons, of course, have to live with such possible intrusion, and no good reason has been suggested by the respondent as to why state prisons shouldn't have to do so also. My Lords, next, my learned friend referred to Brofo in the context of what he says is, at least according to Commonwealth authority, a strong presumption against binding the Crown where criminal liability would or might be involved. I'm not going to take you to it, but the paragraph that he referred to, paragraph 21 of the judgment, the reference is Authorities Bundle 4, tab 40, MS 1744 to 1755. And in our supplementary bundle yesterday, we included behind tab 1 a version of that, of the report in that case, with the paragraph numbers included. But paragraph 21 actually refers to the potential criminal liability of the sovereign herself. And we submit that, as with much of the Commonwealth Authority relied upon, a close analysis will reveal that some at least of the judgments arrived at were based on the old maxim that the king can do no wrong, rather than what we suggest is the correct approach in a case such as the present, which is to analyse what the intention of Parliament must have been by reference to the background and so on. Next, as to the question, well, why didn't the draftsman say in terms that the Crown was to be bound by Part 1 of the Act? My own friend places great reliance on the absence of any such reference in Part 1 in the context of how easy it would be to do so. The fact remains that the draftsman sometimes doesn't so provide, and a recent example of that is the Liverpool coroner's case, where the court found that the Crown was bound by necessary implication by that Act, notwithstanding that there was no express reference to that effect in the Act. Can we also invite you to look at, I don't ask you to do so now, but in Authorities Bundle 5, behind tab 49, at page 409, footnote 65, you will find an audit of Ontario statutes carried out by Professor Hogg in 2010, which found that of 667 statutes in force, only 46 contained an express statement that the Crown was to be bound, despite the fact that many of the others were plainly intended to bind the Crown. For example, the Crown Attorneys Act. So in practice, we suggest parliamentary draftsmen and indeed Parliament don't always refer to a statute binding the Crown, and that is why the necessary implication part of the test applies.
Can you give me an MS number for that, please?
Yes, I'm so sorry. The MS number is is 1906.
Thank you very much.
Can I just go back to your reference to paragraph 21 of Brophy? Yes. Just having looked at it, what they are saying is that there's a very strong presumption that the Crown, him, her, or itself, will not be bound, but a lesser presumption, they suggest, may apply when you're considering whether employees or agents are intended to be bound as a matter of legislative intent. Ultimately, the ultimate question must be whether the presumption against the Crown being bound has in all the circumstances been rebutted, and if it has, the extent to which it was the legislative intent that the particular act should bind the Crown and all those covered by the prima facie immunity of the Crown. So you might have a differentiated position. What's your submission about this Act, if you rely on that paragraph? Do you say this Act has some differentiated intention which we can infer from Part 1?
Well, I don't rely upon that paragraph. My own friend relies on the paragraph to suggest that there is a strong presumption against the Crown being bound, where binding the Crown would introduce potential criminal liability. My point was that if you look at the language used by the court, it's the foot of MS 1744.
Sorry, 1744 is which bundle?
If your lordship's looking at
I was looking at your copy.
at my bundle, well, for those, yes, well, I'm happy to take it from either. Paragraph 21 or MS 1744. If one takes it from the paragraph numbered version, about 5 lines in, if, for example, the question in issue is whether the general words of a statute should be construed in a way which would make the sovereign herself or himself...
Presumption would be extraordinarily strong.
Yes.
But that's what I was putting to you, but how do you say that applies in this case?
Well,
I want to know whether you rely on this, or are you saying, in this case, that you could prosecute the Crown?
I am saying that you could prosecute the Crown, meaning the executive government, but I'm saying that in reality, it's extremely unlikely that the Crown would be prosecuted, because looking at the statute, it's clear that those who are targeted by the statute are those who actually manage in this case, the prisons, rather than the executive government, who won't be directly responsible for whether the right signs have been put up or not, for example. So it's vanishingly unlikely that the...
They could, in theory, be, but it's vanishingly unlikely.
Correct. And indeed, if one looks at the statute, and I think I made this point yesterday, that there are various defences which are provided under the sections which create the offences, all of which refer to whether the person knew that the wrong sign had been erected and the like. And those, of course, are all defences which must be available to the people, the persons who are responsible for the management of the prison, for example, and who are responsible for not putting up the correct signs, to take the same example. My Lords, next, my own friend relies heavily on the fact that the fact that although in some statutes well, let me take your lordships to the reference that I want to take you to. It's the Dumbarton case again, at page 646, which is in the first volume of authorities, MS 646. And it's the point between F and G, which my friend relies upon. The argument is that it's the saving argument. So the conclusion that the provisions in question do not bind the Crown is not, in my view, controverted by consideration of section 146(1) of the Act, which provides in effect that nothing therein shall apply in relation to land belonging to the Crown. The argument is that any such express saving would be unnecessary if the Crown were immune, but as Lord Duparc explained, such saving provisions are commonly inserted ex abundante cautela and are not apt to support the inference that the Crown was in other respects intended to be bound. Our known friend submits that demonstrates the strength of the strictness of the test. We respectfully disagree. We suggest all it does is to indicate that no inferences are to be drawn from such a provision because, as has been widely stated and restated, such provisions are commonly inserted out of abundance of caution. And that's as far as the point goes. And thus no additional weight in support of the strictness of the test is to be relied upon. he then went back to the Commonwealth authorities, this time to Kane and Doyle, and indeed took you to two passages in the judgment of Mr. Justice Dixon in that case. The reference is Authorities Bundle 4, tab 39, MS 1707. And the passages he took you to were from the judgment of Mr. Justice Dixon at 1722 and 1723. Now, this was a majority decision of the High Court of Australia, 3-2, and Mr. Justice Dixon was one of the majority. One of the other majority judges, Mr. Justice Rich, CMS 1717, simply said that he agreed with Mr. Justice Dixon. And as to the third member of the majority, Chief Justice Latham, can I just take you, please, to the foot of MS 1715, where we see that he begins his reasoning on the issue in the case. So MS 1715, by saying it's long been an established principle that the Crown is not liable for a civil wrong unless made liable by statute. In the case of the criminal law, the application of the rule that the King can do no wrong is a fortiori. Never been suggested that the criminal law binds the Crown. Now, just pausing there, it would seem, therefore, that what he says about the criminal law binding the Crown is founded on the old maxim that the King can do no wrong, rather than on the question whether the statute can be interpreted so as to bind the Crown. And in other words, that the Crown that he's looking at there is the King, not the executive government. He does, in the next paragraph, however, go on to say that ministers and officers of the Crown can be guilty of breaches of Commonwealth law, and Parliament could, if it thought proper, subject them to the penalties to which private employers are liable under the Act. But the fundamental idea of the criminal law is that breaches of the law are offences against the King's peace, and it's inconsistent with this principle to hold that the Crown can itself be guilty of a criminal offence. The judge appearing to hark back to what he'd said earlier about the King can do no wrong. Of the two dissenters were Mr. Justice Stark. Can I go to page 1718? Where he accepts at the foot of that page that sovereign bodies may create rights and obligations against themselves and submit the determination of those rights and obligations to the jurisdiction of the court and provide means for enforcing them. And then over the top of the next page, a penal sanction does not seem an impossibility when, as in this case, the judicial authority may order the portion of the penalty to be paid to the employee. If the Act is explicit, the Act is conclusive alike in what it directs and in what it prohibits. And then Mr. Justice Williams, who was the other dissenter, his judgment begins at 1726. And at 1729, he says, second complete paragraph, certainly most unusual, if not unique, for legislation to provide for the prosecution of the Crown, but no constitutional difficulty in the way of the sovereign binding himself in Parliament. The question in each case of the extent to which he's intended to be bound. So the minority plainly adopt the more conventional approach of saying, well, it all comes down to how you interpret the relevant statute. I'll come back to the question of criminal liability a little later in my reply, although I made submissions about that point in the course of my submissions yesterday. My learned friend then suggested that an anomaly that would arise, if were right, is that the Crown would be on both sides in any prosecution under the Act. The reality is, however, that it would be the local authorities who would be prosecuting, since they are the enforcement authority. He next stressed that the cases have rejected the proposition that the Crown is bound if the statute is for the public good, and that is true. But as the Divisional Court said in the Liverpool coroner case, that may be highly relevant to the question whether the Crown is bound by necessary implication. In other words, it may well be a highly relevant factor in the balance to be struck between the factors that point one way and which point another, if that exercise is to be carried out. And the reference is Volume 1 of the authorities, MS 666. Next, Manona Friend's reliance on the proposition that the Crown can be expected to do its duty. Can I make it clear at the outset that we've never suggested that if the Crown is not bound, that there would be a complete void. In other words, as he put it, that the Crown would be inactive. But what we have submitted is that even if the Crown should do its duty, that would fall far short of the protection provided by the 2006 Act. Manona Friend has talked about carefully nuanced government policies which would apply and the freedom of the government to move at its own pace that would be lost. But government policies, we submit, are no substitute for the statutory protection provided by the Act, backed up by the enforcement provisions and, if necessary, regulatory, as we describe them, offences, which Parliament clearly accepted were necessary to protect non-smokers. This morning, Malone Friend suggested that there is no case that has been drawn to the Court's attention where the Crown has been held to be bound by a statute which would expose the Crown to criminal liability. With respect, that's not right, because the Liverpool coroner case is precisely such a case. In the supplementary bundle that we handed round yesterday morning, I took you to, and can I take you back to the relevant schedules to that Act. It's behind tab 3 of the supplementary bundle. And it's the numbering's in the bottom right-hand corner, page 23, offences relating to witnesses and evidence. And paragraph 6, a senior coroner may impose a fine not exceeding £1,000 on a person who fails without reasonable excuse to do anything required by notice under paragraph 1 of Schedule 5. Now, the Divisional Court in the Liverpool coroner case found that the Crown was, by necessary implication, bound by that Act, and that Act provides for financial penalties for a failure to comply with a notice issued under that paragraph of Schedule 5. So
did the Divisional Court, did the Administrative Court address this question at all?
The interesting thing is that the point wasn't even raised by counsel for the Commissioners in support of her argument that the Crown couldn't possibly be bound, because to bind the Crown would expose the Crown to the risk of... Maybe
they missed a point.
Well, if they missed a point, Lord, so did the Attorney General in Gorton, so did the Solicitor General in Cooper and Hawkins, and so did the Solicitor General for Scotland in the Dumbarton case, because all those cases, as I sought to demonstrate yesterday, involved potential penalties for the Crown in the event of breaches of the relevant legislation. And in none of those cases was it argued on behalf of the Crown that to bind the Crown would expose the Crown to the risk of criminal penalties, and that therefore was a very strong factor tending against the Crown being bound by the relevant legislation. So the position domestically is entirely different to the Commonwealth authorities that you've been referred to. There's nothing in the English case law to suggest that there's any presumption, let alone a strong presumption, that the Crown won't be bound by a statute if it would be exposed by the statute to the risk of criminal penalties. On the contrary, the point has been available in all those cases, hasn't been taken, and there's no authority to suggest that the point is a good one. Can I then turn to section 23? I made submissions to report yesterday about section 23. My first submission was that the part 3 and part 1 are not only completely separate, not only address completely separate mischiefs, but they're to be found in completely separate parts of the statute. And it may well be that the government simply decided to gather together a number of completely different provisions in one act. Can I ask you to go back to the consultation paper that you were shown this morning by my learned friend? It's in his supplemental bundle, and it's behind tab 4. And if you would be good enough to go to page 2 of the paper, you will see paragraph 5. This consultation paper puts forward proposed details on the policy outlined in the Choosing Health White Paper. The Queen's speech of 17th of May 2009 announced that legislation to restrict smoking in enclosed public places and workplaces will also be introduced as part of a health improvement and protection bill during this parliamentary session. So what seems to have happened is, as I foretold yesterday, the government decided to add part 1 to a bill that was already in the process of being, as it were, put together. So it is and was happenstance that part 1 came to be found in the same statute as part 3. And whilst my Lord and your Ladyship have...
Sorry, which way round is it? Which is in the original bill, which is added in?
Well, I've read that as being part 1 being added to the Health Improvement and Protection Bill, because it says will also be introduced as part of a Health Improvement and Protection Bill.
Part 1 gets added in.
It doesn't necessarily mean that it's being added to an existing bill, does it? It'll be introduced as a part of a health and improvement protection.
Yeah, I totally accept that, but my point, I suggest, remains valid, that the government was putting together a bill which would encompass various different provisions or parts addressed to various different mischiefs. And thus it was happenstance that the timing of the workup of what turned out to be part 1 meant that Parliament could add part 1 to what turned out to be part 1 to the bill. Whilst you have...
What date was this consultation document?
It is It's June, we know that it's,
June
we-
2006.
we think it's June 2005 because the consultation ran from the 20th of June 2005. That's
Yeah.
foot of page 3.
It says
So-
20th of June 2005.
Well, that's when the consultation,
Publication,
period.
publication date
well then,
on the third page, unnumbered.
well, thank you, Gordon. That was also when the consultation began, yes. Whilst you have it in front of you, can I also ask you to turn to page
Only
7?
introduced in the House of Commons on the 27th of October 2005, the Health Bill.
No, but the
That's not the point. You're saying that there's a compendious bill under preparation in the Department of Health dealing with various aspects of stuff. And the decision was taken to take that legislative opportunity to introduce the smoking thing.
That is my point, yes. But could you also please turn to page 17 of the consultation document, just to pick up the government's objective in introducing smoke-free legislation, because it includes a further objective which we suggest is of some importance. Paragraph 2, the government's objective is to, and then we've got the objective that you're all well aware of already, but then the next bullet point, to recognise a person's right to be protected from harm and to enjoy smoke-free air. So the government's objective went slightly further. I appreciate that it may be two sides of the same coin, but there, the reference to recognising someone's right to be protected from harm is, we suggest, another important part of what the government sought and what Parliament sought to achieve, and certainly what the government sought to achieve with this legislation. Back then to what I was saying about section 23, you have my submissions, which I made yesterday about section 23, and I just want to stress again that we've characterised these as regulatory offences, and indeed I invited you to go to to a reference in the academic articles bundle, which you would have noted, where a distinction is drawn between regulatory offences and true criminal offences.
That's fairly unsatisfactory, isn't it, Mr. Havers? It's a fairly unsatisfactory distinction. I mean, it may not matter for present purposes at all, but all criminal convictions are criminal convictions. You have to disclose them to your insurers. You have a criminal record, and so on.
Well, I entirely accept your Lordship's point, but the reason why the distinction, at least in terms of language, may be of some assistance, is that it indicates a raft of offences which fall within, and the Health and Safety Act was referred to earlier today, fall within that sort of category, where what Parliament is trying to do is to regulate particular areas of public life, such as regulating smoking in prisons by creating offences in addition to the various other enforcement provisions which will apply. And as you have all seen from the statute itself, the only penalties that are in play here are financial penalties. There's no question of imprisonment being in play. So I repeat the submission from yesterday and apologise for doing so. It's no surprise, we say, that Parliament should have intended the Crown to be bound by Part 1. The mischief was plainly an extremely serious mischief, and in the overall scale of things, one can understand why Parliament may have taken the view that it was more the mischief that needed to be addressed was of a different order of gravity than the mischief which Part 3 was intended to address. In other words, to address the safe management of controlled drugs. But, my Lord, even if your Lordships conclude that there is some force in the Section 23 point, there are other, it is but one factor for the court to consider, to weigh up, as against all the other factors that we have commended to the court as pointing in the other direction. That takes me to the Section 10 of the Scottish Act, which you were shown this morning, leaving aside the assistance which this court is going to derive in construing the English Act by reference to the Scottish Act, that the upshot, according to learned friend, is that notwithstanding that in Scotland Crown servants are undoubtedly liable, criminally liable, for offences under the no-smoking regime, if I can put it in that way in general terms, they're not liable in England and Wales because it is said that the Act doesn't bind the Crown. Now, no explanation has been offered by my learned friend as to justify any such extraordinary, to justify such an extraordinary state of affairs. My learned friend next suggested that the Court of Appeal in the present case that their decision, their reasoning didn't turn on the adverb wholly in the expression wholly frustrated, and took you to, or referred you to, the relevant paragraphs from their decision. But can I just ask you to pick up the Authorities Bundle 1, because we suggest that that isn't a fair reflection of what the Court of Appeal did. If you would go, please, to paragraph 32, which is at MS 707. There is the Court of Appeal, or Lord Dyson, begins paragraph 32. The test may be satisfied if the statutory purpose would be wholly frustrated, were the Crown not to be bound by its terms. Then he proceeds to consider whether it would be. And at paragraph 39 at MS 709 concludes, I do not accept that the purpose of the Act would be wholly frustrated if Chapter 1 of Part 1 did not apply to the Crown. We submit it. It's clear that that was the test that the Court of Appeal were applying. Next, can I go back to the white paper, which my own friend took you to. And the reference was Appendix 407 MS 532.
Sorry,
MS 532.
thank you.
Now, he suggested, looking at the left-hand column, that shifting the balance significantly in favour of smoke-free environments was achieved. The government policy thereafter was to that effect. We would submit, and I hesitate to spend long on this because this was a white paper that was then followed by consultation, that was then followed by the Act itself. But we would submit, for what it's worth, that what the white paper was clearly referring to here was a shift from voluntary compliance on the one hand to legislation on the other hand.
Well, can that be right? It says with legislation where necessary.
It says with legislation where necessary, but then one goes on to see all enclosed public places and workplaces other than licensed premises will be smoke-free. And then when one gets to paragraph 77, at the first bullet point, a staged approach, by the end of 2006, all government departments in the NHS will be smoke-free. Well, that, obviously, all government departments falls far short of all Crown premises, and certainly doesn't include prisons. But perhaps my best point on this is to invite you then to turn to the consultation document, which was handed up this morning, and to page 9. It's behind tab 4. Page 9, paragraph 23. No.
That's right.
Yes,
Yes.
page 9, paragraph 23. That's right. Because by now, we see what the department's position was. 23, it is proposed that regulations may exempt the following premises from the smoke-free legislation, since they act as an individual's dwelling or are clearly private space. And then there are set out the various examples, references to what we've seen, places occupied as residential premises, halls of residence and so on, and then prisons or other places of detention. So what was plainly then being consulted upon was exempting prisons from the legislation, which, in other words, what was the premise was that prisons would otherwise be covered by the legislation. Finally, I think, my own friend took you to the material in the appendix that comprised the government's response to the House of Commons Health Committee's first report, and in particular to paragraph 7. Now, Mr. Justice Singh addressed this in some detail in paragraphs 71 to 77 of his judgment, and the MS reference for that being, so sorry, authorities. They got one there. I've mislaid authorities bundle 1. Thank you very much. The reference being 684, and he concluded that what had been said by the government should not be relied upon for the reasons he there sets out. That there was no subsequent attempt by the respondent in the Court of Appeal to revive the argument, and it hasn't been revived.
Well, what was he doing? He was rejecting it as an interpretive aid to the statute, is that right?
Correct.
Yes, I don't think that's what's being suggested. What's being suggested is that it's perfectly plain that the point had been flagged up.
Yes. Well,
Okay.
And yes.
Well, is it legitimate to look at it for that purpose?
Yes, well, I understand.
Okay.
But that's as far as it goes.
Yes, I think.
Which isn't very far, we suggest.
All right.
I thought it was being relied upon as part of the mischief, which is indirectly part of the interpretive process, isn't it?
Well, it's yes, but that simply takes us back to the question whether government policies about which we've heard nothing in terms of materials before the court, as to whether government policy is an acceptable substitute for the protection provided by the Act. And I said finally, but can I just add this? Some of your lordships, my lady, referred to the PSI, the relevant prison service instruction, which plainly assumes something else. Can I just remind you of page 445 in the appendix? That's MS 570. The document published in January 2007 by the Department of Health and the Prison Service.
Yeah.
Which, and the forward to that document, which I showed you in my opening. My lady and my lords, unless I can assist you further, those are my submissions in reply.
It seems that we've also run out of steam in bombarding you with questions, Mr. Havers. Thank you very much indeed to everybody for their submissions, both orally and in writing. So that includes everybody sitting behind the front row, because I'm sure they've made a big contribution. One imagines, Mr. Havers, that when your client launched these proceedings, he didn't quite realise what a deep constitutional question was going to be raised.
I can't be sure of that because I haven't asked it, but I think your ladyship is almost certain.
It's just a surmise, yes. Nevertheless, that is the case, yes. And so we shall go away and put our thinking caps on. And thank you all very much. We'll let you know the result in the usual way.
Thank you.
Court is now adjourned.